all's fair in love and war, the High Court's decision in Love and Toms. Now, I will adopt a fairly legal style here, and the politician in me will from time to time break out into a little bit of discussion, but there is a paper and it will be circulated shortly after this talk. You didn't get it beforehand because I want to make sure you have to listen in any event. So 6 months after there was a change in the composition of the bench, Chief Justice Barwick suggested that the first Territory Senator's case should be promptly challenged. He thought it important that that occur before it becomes entrenched in constitutional practice by the mere passage of time. Not one to miss a hint, the State of Queensland quickly challenged the decision, and the High Court heard the second Territory Senator's case less than 2 years after the first one was handed down. No doubt Chief Justice Barwick's warning will be echoing now across this country after the High Court's, in my view, narrow and divisive ruling in Love and Toms, which has radically altered the way we understand the aliens' power. However, with 2 of the majority justices in Love reaching the mandatory age requirement for retirement within the year, there's a significant possibility that a reconstituted bench would consider the decision afresh in the event of an appropriate challenge. So I'm going to do 4 things in this paper. In part 1, I'll take you briefly through the legal background for the small number of you who might not have read it. The second part, I'll explain why I believe the decision is thoroughly unsatisfactory, in short, for reasons of judicial activism, engaging in policy making and racial divisiveness. In part 3, I'll go through what options are available to the government, in my view, in seeking to repair the situation, including whether we go to a referendum, whether we could legislate under a different head of power, or whether it would be possible to challenge Love under a reconstituted bench. And finally, I will look at the future of judicial appointments and what we should be looking for in the people that we appoint to the court. And hopefully I'll provide good support for my ministerial colleagues in doing so. So the plaintiffs in the Love case were Daniel Love and Brendan Toms. They were born in PNG and New Zealand respectively, and they were citizens of those countries, not of Australia. Both plaintiffs resided in Australia on visas that were capable of being revoked, and they weren't citizens pursuant to the Citizenship Act. In 2018, Mr. Love was convicted of an assault occasioning bodily harm that breached Section 399 of the Queensland Criminal Code, and he was sentenced to 12 months of imprisonment. Mr. Toms was convicted under Section 399 sub 1 of the same criminal code of a domestic violence offence, and he was sentenced to 18 months of imprisonment. That meant both of them were in breach of the character test that exists in Section 501 of the Migration Act, and that meant that the minister subsequently cancelled their visas. That meant, pursuant to Section 13 and 14 of the Migration Act, they became unlawful non-citizens and subject to deportation. And so those 2 plaintiffs lodged a High Court challenge claiming that as Aboriginal people, they weren't within the reach of the aliens' power, which provides the legal basis for the Migration Act. Mr. Love is a descendant of the Kamilaroi group and has been accepted as such by one elder. Mr. Toms identifies as a member of the Gungari people, and he has been accepted as such by that group. Additionally, Mr. Toms is a native title holder under common law. So prior to the outcome in Love, it was relatively settled in this country that an alien is the inverse of a citizen, such that if one isn't an Australian citizen, then they must be an alien. No one seemed to think that was especially controversial. At the 1898 Constitutional Convention, a proposed head of power for citizenship itself was rejected. The naturalisation and aliens formulation and the separate immigration and emigration formulation were regarded as sufficient for grounding a statutory basis for citizenship. That has meant that the court has long left it to Parliament to create, define and set the criteria for citizenship and its antonym, alienage. Additionally, the court has previously rejected the existence of a category of non-citizen, non-alien, which, as you'll no doubt be guessing, is pretty important in the present case. In 7 separate judgments, the High Court, by a majority of 4-3, found that persons satisfying the tripartite test for Aboriginality, for those who don't know, that means biological descent, self-identification and acceptance by the Indigenous community, are not within the reach of the aliens' power conferred by Section 51(19) of the Constitution. The majority rejected the existing line of precedent, holding that alienage and citizenship are not inverse concepts, and thereby created an entirely new category of non-citizen, non-alien. Relying on the concept of unique connection to land, the majority found that Aboriginal Australians are said that relying on the unique connection to land that Aboriginal Australians are said to have, the majority concluded that Aboriginal persons cannot be considered aliens. Now, the minority strongly disagreed with that and rejected the existence of a category of non-citizen, non-alien. Now, the majority's reasoning, in my view, is entirely unsatisfactory, and that's for a number of reasons. First, the majority engage in what is very clearly judicial activism. They interpret the aliens' power in a manner that is unguided and unbound by the Constitution itself. Chief Justice Kiefel points this out quite brilliantly, I think, when she says Section 51(19) is not expressed to be subject to any prohibition, limitation or exception respecting Aboriginal persons. The task of this court in interpreting a provision of the Constitution is to expound its text and, when necessary, ascertain what is implied in it. Now, that shouldn't be a controversial concept, and yet the majority rely on vague concepts like, quote, metaphysical bonds. Another quote is connection with land or waters, and another one which I think speaks very much to the postmodern way of thinking, deeper truth. None of which are expressly or impliedly in the Constitution, nor have they been recognised as constitutional concepts at any point before. Justice Gageler decries this as judicial creativity, resulting in the creation of an unexpressed limitation or exception to the alien's power. Now, such a drastic change to the Constitution as this is, was always intended to be brought about by referendum, not by judicial whim. The Constitution should not so dramatically change by the actions of an unelected and unaccountable group of people deciding on the basis of their policy preferences rather than their legal role. Chief Justice Kiefel warns against this type of approach. She says, questions of constitutional interpretation cannot depend on what the court perceives to be a desirable policy regarding the subject of who should be aliens or the desirability of Aboriginal non-citizens continuing to reside in Australia. The point is that in the absence of a relevant constitutional prohibition or exception, it is not the proper function of a court to limit the method of exercise of legislative power. What a good Queenslander she is. Her Honour goes on to conclude that the approach submitted by the plaintiffs and accepted by the majority is antithetical to the judicial function, since they involve an appeal to the personal philosophy or preferences of judges. Chief Justice Keane, another Queenslander I might note, also points out an important contradiction. If Aboriginal people occupy a special or privileged constitutional position vis-a-vis their connection with the land, as was put by the majority in their decision, then why is there a need for constitutional recognition of Indigenous Australians? I thought that was quite a brilliant point. Isn't the fact that the Constitution is silent on Aboriginality the very reason why constitutional recognition is advanced by proponents in the first place? The answer to these questions is that the majority's reasoning is not grounded in the Constitution. To borrow from the language of the Chief Justice, it's grounded in external matters of values and policy, usurping the role of Parliament. its constitutional interpretation wholly unmoored from the constitutional text. That is, in short, judicial activism. Further, in discarding a long line of aliens power jurisprudence, the majority relies on the decision in Mabo to provide legitimacy for their reasoning. But they do so in what should be understood as an erroneous manner. For instance, the majority uses the common law native title requirement of connection to land to answer a constitutional question. And that approach is described by one of the minority judges beautifully, I think, as wrong as a matter of law and logic. Further, Mabo itself acknowledges that connection to land can be lost, while the majority in Love seem to assume that all Aboriginal people have a special connection with land that is not capable of being broken. And when thought of that way, it really is quite an extraordinary step. So, what are the policy implications of this? I see two immediate policy implications. There's the creation of a loophole in the government's policy of deporting non-citizens who've been convicted of serious crimes, allowing dangerous non-citizens to avoid deportation if they can establish Aboriginality. Justice Gageler criticises this judicially created loophole, arguing that it would generate complications and uncertainties for the maintenance of an orderly national immigration program under the Migration Act. Unfortunately, we are already at a governmental level starting to see this play out. Less than 1 month after Love was handed down, 23 immigration detainees came forward with claims of Aboriginality. In estimates, the Department of Home Affairs' General Counsel, Ms. Pip DeVoe, said that in some cases those seeking release had provided no evidence beyond their own assertions to support their claims. Further exploitation of this supraconstitutional innovation, isn't that a great way to describe it, can be expected after Shane Martin, the father of AFL star Dustin Martin, claimed he too was Aboriginal when faced with deportation to New Zealand. As an aside, it's somewhat ironic that there are many in the mainstream media who have celebrated this decision as a win for Indigenous rights, while overlooking their positions on many other causes, like the fact that a domestic violence offender in Mr. Toms has been enabled to remain in the country. It's an interesting arrangement of priorities from those who are most enthusiastic about identity politics. Second, the decision outsources control over immigration and security policy from the legislature to Aboriginal societies. And that's because determinations of Aboriginality under the Mabo test require those 3 steps: biological descent, self-identification, and, importantly for the purposes of this, acceptance by the relevant Indigenous community. In essence, this gives Aboriginal and Torres Strait Islander societies the capacity to decide who is and is not an alien, thereby depriving the Commonwealth Parliament of an aspect of its power under Section 5119. As Justice Gageler so eloquently states, it cedes to a non-constitutional, non-representative, non-legally accountable subnational group a constitutional capacity greater than that conferred on any state parliament. Let that sink in for a moment while I drink my tea. Chief Justice Kiefel follows that to accept this effect would be to attribute to the group a kind of sovereignty which was implicitly rejected in the Mabo decision. Further troublingly, Justices Bell and Edelman appear open to weakening the tripartite test from Mabo, suggesting that it might be possible to successfully claim Aboriginality without fulfilling that 3-part test. It would be so very disturbing if biological descent or self-identification alone were to become sufficient. However, what is most concerning about this decision are, I think, the yet to be realised and perhaps unintended consequences arising from the majority's reasoning. For instance, Justice Nettle concludes that the Crown owes a, quote, unique obligation of protection to Aboriginal societies. Now, exactly what that imposes on the government and how far that extends into other areas of constitutional law is far from clear. Justice Keane wisely warned that such a duty does not come without costs if it exists. Indeed, if Aboriginal Australians are exempt from the alien's power by virtue of a unique duty or a special connection with land, well, what other areas of law are they exempt from? Alarmingly, these notions of obligation of protection and connection with land are elevated to constitutional concepts by this case, meaning that unlike native title, they can't be curtailed or legislated away. On the other hand, by grounding non-alienage in whether one is a belonger to an Australian political community, to use his terms, Justice Edelman leaves space for further groups of people to argue that they too should inhabit a category of non-citizen, non-alien because they are belongers to the Australian political community. Thus, it's entirely possible that this new category of people could be broadened beyond Aboriginal people and further diminish the Commonwealth's power to deport criminal non-citizens. Justice Gageler concludes that such concepts inject an element of indeterminacy into the administration of the legal status of alienage. I think it is fair to say that the majority have opened up here an enormous can of constitutional worms. The decision should also be criticised for its divisiveness, in my view. It divides those who reside in Australia along racial lines like nothing we've seen before. For example, the finding that indigeneity provides for an exception to Section 5119 results in the creation of a race-based constitutional limitation on legislative power. We have, that's an extraordinary thing. Justice Gageler protests that he cannot be party to a process of constitutional interpretation with this consequence. If you haven't read his judgment, it really is very good. As a result, convicted criminals facing deportation under identical circumstances would receive different treatment according to race. While the Australian community was previously divided along citizenship lines, a category of citizens, a category of aliens, we now have an entirely new class based on race, that is, the non-citizen, non-alien. As Caroline de Russo has claimed, it's ethno-nationalism frocked up as progress. Indeed, the theorised obligation of protection owed by the Crown to Aboriginal societies reeks of rank paternalism, to quote Justice Keane, I believe. In a modern egalitarian Australia, these sorts of distinctions that have been drawn by the court are objectionable. They work only to divide Australians rather than to unify them. As Justice Keane rightly concludes, considerations of race should be irrelevant to the requirements for membership of the Australian body politic. I give that one a big hear here. I might move on to part 3, and that is to deal with remedies. How do we fix this problem? Well, the first option is a referendum. The government could pursue a referendum on the matter, but as those who take an interest in our constitution know, they're costly, they rarely deliver the desired result, and their success rate is at about 18%, rarely successful unless supported in a bipartisan kind of way. The economic and health impacts of COVID-19 would make it difficult for the government to justify, I think, that spending in the current times. But perhaps even more concerningly, it is, I think, likely that to put forward a referendum on the issue of love would invite the consideration of the question of constitutional recognition of Indigenous Australians in a more substantial way at the same time. So for someone who is a constitutional conservative on that question, as I am, the pursuit of a referendum to correct love may end up being a counterintuitive pursuit, even noting what has been said by Chief Justice Kiefel about the strange relationship between, and indeed Justice Keane, the strange relationship between pushing for Indigenous recognition in the Constitution and the simultaneous existence of this interpretation. So what else can we do? We could look to a different head of power. There's the immigration and emigration power, and that's section 51.27. Justice Gageler suggests in his judgment that this might be an option, but the doctrine of absorption limits the usefulness of this part of the Constitution quite substantially, I'd suggest. In Ex parte Walsh, re Yates, the court held that once immigrants who remain non-citizens are absorbed into the Australian community, they cannot be deported under the immigration power. This found the clearest expression in the judgment of Chief Justice Knox, who said, "A person who has originally entered Australia as an immigrant may, in the course of time and by force of circumstances, cease to be an immigrant and becomes a member of the Australian community. He may, so to speak, grow out of the condition of being an immigrant and thus become exempt from the operation of the immigration power." That is, without becoming a citizen. While this proposition was contentious for some time, it's now settled law that absorption takes one outside the scope of the immigration power. So, for instance, in Ex parte Henry, Justice Jacobs reiterated that a day comes when an immigrant is absorbed into the Australian community so that he cannot thereafter be deported under the immigration power. In Johnson, and the Minister for Immigration and Multicultural and Indigenous Affairs, Justice French, as he then was, provided a detailed and, he said, non-exhaustive list of whether or not he becomes so absorbed. And he gave a long list of factors, some 9 of them, everything from the time that has elapsed since entry into Australia, the number and duration of absences, the existence and timing of forming an intention to settle permanently, the presence of family members in Australia, employment history, ties to Australia, property ownership, economic ties, participation in community activities and a criminal record. It's a pretty expansive list. And it makes it quite easy for immigrants to reach the test of absorption into the Australian community, so that there's very little scope for the use of deportation under this power. It was for this reason that the Hawke government introduced the Migration Amendment Act in 1983, which switched the constitutional basis of the Migration Act from the immigration power to the aliens power, and that made deportation easier. So while the deportation of Aboriginal non-citizens would still theoretically possible if we were to rely on the immigration power, the Commonwealth's ability to do so would still be, I suggest, severely restricted by the doctrine of absorption. It'd really only help in circumstances where you were dealing with a person who had very little connection to the Australian community. So let's have a look then at the race power, section 51 sub 26. Justice Gageler suggests that the Commonwealth Parliament might consider itself obliged to address this problem through racially targeted legislation enacted under that provision. The race power was amended, as most of us know, in the 1967 referendum, and it gives the Commonwealth power to make laws with respect to the people of any race for whom it is deemed necessary to make special laws. It's well settled that the race power allows the making of laws for the benefit of Aboriginal peoples, but there is no clear ratio available to us, at least on my reading, on how that stands post-referendum for the use of the power for the detriment of Aboriginal peoples. There's obiter both for and against that proposition. For example, Justice Murphy in both Kuata and Bjelke-Petersen and the Commonwealth in Tasmania argued that the power is limited to laws benefiting Aboriginal people. And Chief Justice Brennan in the Tasmanian Dams case found similarly. However, Chief Justice Gibbs in the Kuata case and Justice Dean in Tasmanian Dams suggested otherwise. Its status remains uncertain after Cutinieri in the Commonwealth, with Justices Gummow and Hayne concluding that the power could be used in a detrimental way, but Justices Gaudron and Kirby concluding that it could only be used beneficially. Chief Justice Brennan and Justice McHugh didn't consider that aspect at all. So there is a question, a live question, about whether or not an act that purported to use the race power to correct this problem would be seen as detrimental. I expect that's true, but whether or not a detrimental action would fit within the scope of the race power as it currently stands. The conclusion of both of those heads of powers analysis, I'd suggest, is that both of them involve considerable risk, and they ultimately fail to entirely fix the problem at hand. As Justice Gageler concluded, on a correct understanding of the scope of the power conferred by Section 5126, neither is a course which the Commonwealth, so did I say 5126? Sorry, 5119. Neither is a course which the Commonwealth Parliament ought to be driven to take. So what else can we do? While it lies beyond the power of Parliament to restore Section 5119 to its pre-Love meaning, the High Court can overturn that decision and thereby revert to its previous jurisprudential understanding of the alien's power, or indeed some other view. That outcome isn't entirely out of the question. With two of the majority justices leaving the bench within a year, there is a significant possibility that the decision could be overturned in the event of a challenge. That prospect invites an analysis, I'd suggest, of the court's jurisprudence regarding the doctrine of precedent. The High Court has always asserted its ability to reconsider and overrule its past decisions. If we go back to Agricultural Company and the Federated Engine Drivers and Firemen's Association of Australia, Justice Isaacs famously proclaimed it as such. He said, "It is not better that the court should be persistently wrong than it should be ultimately right." While this view was accepted by the court, a more cautious approach to overturning precedent was ultimately endorsed. In Ex parte, the Brisbane Tramways Company, Chief Justice Griffith stated, "It is impossible to maintain as an abstract proposition that the court is either legally or technically bound by its previous decisions. Indeed, it may, in a proper case, be its duty to disregard them. But the rule should be applied with great caution, and only where the previous decision is manifestly wrong." So the clearest expression of what conditions can make it easier to depart from precedent can be found in the Second Territory Senator's case, close to where we began this talk. In the Second Territory Senator's case, the High Court was invited to overturn a 4-3 majority decision it had made just 2 years earlier. The composition of the bench had changed, with Justice Aiken replacing Justice McTiernan from the original majority. Given the short length of time that had elapsed since the original decision, the court discussed the doctrine of precedent at great length. And similarly, they came up with a list of the factors that make it easier to overturn a previous decision. The 6 main factors that were identified were: the earlier case is manifestly wrong. Second, it is isolated, nor part of a well-established stream of cases. Third, the earlier case is contrary to long-established authority. Fourth, the earlier case is decided by a narrow minority. Fifth, the earlier case is on a constitutional question. And sixth, the earlier case is recent. I'd suggest the decision in Love meets all 6 of those criteria. In addressing the importance of the Constitution as compared to the doctrine of precedent, Chief Justice Barwick said, "It is the duty of each justice to decide what, in truth, the Constitution provides. The area of constitutional law is preeminently an area where the paramount consideration is the maintenance of the Constitution itself. Convinced of their error, the duty to express what is the proper construction is paramount." So getting our constitutional interpretation right is far more important than notions of precedent or judicial courtesy. But ultimately, Chief Justice Barwick was unsuccessful in that view prevailing. While finding the decision in the First Territory Senator's case to be wrongly decided, Justices Gibbs and Stephen nevertheless applied that principle. While acknowledging the above factors were legitimate considerations, Justice Gibbs held that change in the composition of the bench was not a sufficient reason to overturn the precedent, though he did warn that any further deterioration in the federal balance would cause him to reconsider his position. The legislation was thus upheld by an increased majority of 5-2. When he spoke extracurricularly on the matter, Sir Harry Gibbs also emphasised the importance of certainty in the law when he upheld the precedent, noting that there had already been senators for the Northern Territory elected. He thought it would be a most drastic step to deprive citizens of a right to representation in Parliament, given that the court had once upheld that principle. On the other hand, in this case, overturning Love would increase certainty in the law. So one could argue that to overturn Love would have some consistency with the reasoning offered by Sir Gibbs. The outcome in the second Territory Senator's case can be contrasted with two contemporary examples where the High Court has swiftly overturned constitutional precedent upon a change in the composition of the bench. In Gould and Brown and in Rewa Kim ex parte McNally, there was quite rapid overturning of earlier precedent. In Gould, the court upheld the validity of a jurisdictional cross-vesting scheme. 1 year later, the court completely reversed that decision, invalidating the same scheme after Chief Justice Gleeson and Justices Hayne and Callanan joined the bench. The second example relevantly concerns the Aliens' Power. In a 4-3 split judgment in 2001, the court in Re Patterson, ex parte Taylor, held that certain non-citizen British subjects in Australia could not be considered aliens, creating for the first time a category of non-citizen, non-alien. But nevertheless, the decision was overturned just 2 years later in Shaw and the Minister for Immigration and Multicultural Affairs, when Justice Hayden replaced Justice Gaudron on the bench. The new majority in Shaw returned its earlier jurisprudence, holding that non-citizens are aliens. Justice Gageler acknowledged that about-face in his decision in Love, describing the creation of a category of non-citizen, non-alien as, I thought quite cleverly, a constitutional cul-de-sac, implying that the court is embarking on a similar path to Patterson and Shaw. Therefore, just as Patterson has come to be considered a momentary departure from the Aliens' Power jurisprudence, it is entirely possible that the decision in Love will too. Indeed, the result in Patterson and Shaw is certainly more analogous to the situation in Love than the second Territory Senator's case is. So, given this, I think the approach of the High Court in recent years demonstrates greater flexibility and a greater readiness for overturning constitutional precedent, even where there has been a reconstitution in the bench. Chief Justice Barwick's view seems to have won the somewhat guarded support of the court in Lange. Errors in constitutional interpretation are not remediable by the legislature, and the court's approach to constitutional matters is not necessarily the same as in matters concerning the common law or statutes. In any event, those attending might be unsurprised by my view that the perspective put forward by Justice Callanan in the work choices decision represents what I would suggest is the most desirable approach. His Honour then said, "No doubt careful deference should be paid to the doctrines of the court as and when they can be identified and can be seen to be consistent, but it is not right for a judge to seek refuge in those doctrines to avoid the undertaking of an independent analysis informed by the past of the Constitution." Now, this is by no means an exhaustive outline of the High Court's history and jurisprudence regarding overturning constitutional precedent, but it is illustrative of a key point. While a range of common factors toward overturning precedent emerge, ultimately the fact is that different judges take different views of how much respect to pay to past precedents, particularly when they're in a constitutional case. Predicting whether the minority justices in Love would overrule it in a subsequent challenge is therefore a fraught exercise, to be frank. Notwithstanding some of the factors already identified, I think there is nonetheless some reason to believe they might overturn love if given the chance. For instance, Justice Gageler continually refuses to apply the majority test of structured proportionality in implied freedom of political communication cases, preferring to apply his own test of calibrated scrutiny. And given this refusal, I'd suspect it's unlikely he would rule to uphold love, particularly given the vigour with which he dissented. He particularly strongly said, "I am unable to accept the plaintiff's argument in any of its variations. The plaintiff's argument is not legally sustainable." And Chief Justice Kiefel and Justice Keane are similarly strong in their dissent. Indeed, Chief Justice Kiefel notes that the decision in Love goes much further than what was accepted in Patterson and overruled in Shaw. But ultimately, the outcome will turn on the attitude of the justices towards the doctrine of precedent. If recent history provides any guidance, I think there is hope for Love being overturned under a reconstituted bench rather than the present one. And so that brings us, I suppose, to the importance of the fourth part of this paper, and that's the topic of future judicial appointments. Excuse me a moment. Given that 3 of the 4 majority justices in Love were appointed by the current government, of which, full disclosure, I am a part, many conservative commentators have queried how such an activist result could arise, labelling it an utter failure of the federal coalition. Such concerns are not entirely misplaced. So what can be done about this sorry state of affairs? As Morgan Begg pointed out in a very good piece he wrote, the 2 upcoming High Court appointments are the 2 most consequential appointments in this federation, and Australians cannot afford for us to get these appointments wrong. So how do we get it right? I'd suggest that the right approach to take in looking to who would be an appropriate judicial appointment is a screening of candidates for their judicial methodology. That must be done with great care and consultation. The overriding factor in judicial selection must be a black letter approach to constitutional interpretation. That means selecting judges who will interpret the Constitution based on an originalist approach, not based on righting perceived policy wrongs in the present day or playing with some living tree. Dyson Heydon, former Justice Heydon, spoke extracurrially to the distinction between a black letter judge and an activist judge in 2002. He stated that a black letter judge is, quote, an independent arbiter not affected by self-interest or partisan duty, applying a set of principles, rules and procedures, while the activist judges decide cases according to some political, moral or social program. We can clearly see this playing out in the majority in Love. Such appointments should safeguard the Constitution from further judicial alteration by activist judges. Now, some will say that this is merely an attempt to politicise the bench. Now, that criticism, I think, is misplaced in 2 ways. One, it ignores the reality that they are appointments made by politicians. And so to suggest that politics is entirely irrelevant is to decline to live in the real world. But more importantly, let's be clear, we're talking about screening candidates for their judicial methodology, not the way they vote, not whether or not they hold a membership card for a particular party. A black letter judge is not someone who necessarily votes for or supports the Liberal Party. That is not what I'm advocating for. What I suggest we need is quite the opposite, that judges be appointed who interpret and apply the Constitution based on the original intent of our founding fathers, not based on their own politics in the present day. They need strict fidelity to the words of the Constitution, not strict fidelity to the whims of any political party. Indeed, appointing appropriately black letter judges will curb the influence of politics on the bench rather than encourage it. It is activist judges who harm the independence of the judiciary, after all. As Sir Harry Gibbs noted very wisely, it is disturbing that there is a perception that some federal court judges decide cases according to their ideological biases rather than according to law. The appointment of black letter judges will thus only serve to bolster the independence of the judiciary. And, you know, let's be honest, let's not pretend that Labor doesn't nominate political appointees to a large number of bodies, even as they might bleat about this. It is, in addition to being a conservative in one's judicial methodology, rather than in a political sense, it is also desirable that judges possess a certain level of social skill, including skills of persuasion, relationship management, and the ability to build consensus around good ideas. Dare I say it, those are also skills that make for a good politician. This will produce a greater number of majority judgments in support of the superior legal methodology. Additionally, as the final court of appeal in a federation of states, considerations including state of origin and attitudes towards federalism itself must also be front of mind when making appointments. So while it's all well and good to suggest that judges with a black letter methodology be appointed, how can we be certain that they will subscribe to such a method once they are given the great privilege of tenure? And more importantly, how do we ensure that the next generation of judges aren't activists, given the sustained rise of intellectual leftism across our universities? I'm going to go out on a limb and say the answer may be more obvious than we think. The answer may well be an enlarged role for a body like the Samuel Griffith Society. Judicial conservatives in Australia might consider adopting a similar strategy to that pursued by the US Federalist Society. For those who haven't read much about it, it was established in 1982 primarily as a networking opportunity for young legal conservatives. And it's been instrumental in wrestling the left's hold, or wrestling from the left its hold of legal institutions across the US, particularly the courts. It is wonderful that we have the foundations of a comparable body here. There are two areas in which the Samuel Griffith Society may endeavour to follow the path that has been set by their US counterparts. The first is in the counselling of judicial appointments. The Federalist Society has played a key role in counselling US presidents and their advisors on people who would make good judicial appointments. They were the prime source of advice for President George W. Bush, and President Trump has been known to consult with the Federalist Society. It should be common practice for an Attorney General to consult with the Samuel Griffith Society with respect to potential nominees. And like their US counterparts, the Samuel Griffith Society should be insistent that nominees have a voluntarily demonstrated black letter approach to constitutional interpretation, and that they have a track record of defending it in their time prior to their elevation. They can serve as an important screening mechanism, and the reliability of this screening would be enhanced by the cultivation of young conservative legal talent, which I suggest is a second function that the Samuel Griffith Society has already reached into rather well. The recruitment and development of law students and young lawyers who have been identified as having an originalist approach is high value. US political scientist Stephen Tellez gives a detailed account of how the Federalist Society has been successful in recruiting law students. The key, though, has been a strong commitment to intellectual debate on university campuses. Rather than simply sponsoring speakers for external events, the Society emphasises debate, engaging on campus, holding those events there with students and academics with different perspectives invited to spar and defend their points of view. By being open, reasoned and willing to engage with students, the Society presents itself as a really appealing alternative to the university left, who are largely closed off, elitist and unwilling to debate. As a result, students are more willing to be convinced of the society's ideals, and it has gone a long way towards restoring ideological balance in US law schools. Those students, once recruited, are supported and developed as their career unfolds, offered a network with experienced people in the profession. They have access to pitch themselves for clerkships with judges and opportunities to write and speak on the matters that are important to them and their career. It means that Federalist Society members who have grown in the society since law school have a long list of people who know them well, who trust their reasoning, who trust their character, and they have been much better vetted than the process often adopted in Australia of a few names being suggested to people on high and one of them being picked after a reference from some colleagues. It's just a degree of screening and thoroughness more likely to bring out the kind of interpretation we want to see as not just protecting our constitution, but bringing out the best in our polity. So to conclude, I find the High Court's decision in Love disturbing. I think you've picked up on that. It strays from the text of the Constitution into matters of values and policy. It divides our community along racial lines. And for what noble pursuit? To allow convicted criminals to remain in Australia by virtue of their race. You know, it is this horrid mix of identity politics with judicial activism. And I think it is imperative that opportunities for a court to reconsider it be proffered in circumstances of some wise appointments being made over the coming few years. If left unchallenged for too long, I think there's no telling how far down this constitutional can of worms we will go. As Portia from Shakespeare's The Merchant of Venice proclaimed, "'Twill be recorded for a precedent, and many an error by the same example will rush into the state." Thank you very much for patiently listening. I'm happy to take questions or comments or anything else you'd like to with the time remaining.